In other business news, the legal practitioners, estate agents, casinos and trust service providers have been identified as sectors that are posing a challenge in efforts to remove South Africa from the grey list. The Financial Intelligence Centre says this group has failed to heed directives aimed at meeting the sought reforms set by the Financial Action Task Force. The FATF found South Africa wanting in its measures to prevent fraud and terror funding. The FIC's Augustyn says while progress has been made to address these matters, it's a concern that some sectors are not coming to the party. He joins us live now to further this conversation. Thank you so much for your time. Let's talk about the identified sectors. What exactly are they not heeding in the directives given?
Very good afternoon to your viewers, to you and your viewers as well. What they're not heeding to is the directive that we issued in 2003, in March 2003, requiring of accountable institutions, and specifically the attorney sector, the legal practitioner sector, which consists of attorneys and trust advocates, and also the estate agents, to complete a questionnaire that indicates to the FIC what are the risks that these institutions face for purposes of money laundering and terrorist financing. So the questionnaire has a dual purpose. On the one hand, it provides insight to the estate agent or the attorney, what are the money laundering risks that it faces. And on the other hand, it provides to the FIC an opportunity to supervise properly and focus its efforts on the higher risk institutions in those areas. So the problem that we faced was that where we're standing now, they have not yet, 40% of attorneys have not yet submitted their RCRs, and about 35% of the estate agents haven't submitted their RCRs. And that puts us at risk with the FATF, which have placed us on the grey list. And it places the FIC in a position where we cannot turn a blind eye. We need to take enforcement action, and we have been taking enforcement action. Yeah. And that's where we are at the moment.
Enforcement is required essentially because South Africa is chasing a deadline to meet the FATF's requirements. But I'm interested in finding out whether there's been any justification why these sectors are not coming to the party.
Well, that's a good question. You know, the issue is it's mind-boggling to an extent, because we've done so much outreach, webinars, and interactions not only with the accountable institutions, the estate agents and the attorneys and the trust and company service providers themselves, but also with their regulators, their licensing bodies, industry bodies, and the like. And it simply boggles the mind. I think it boils down to a large extent to a notion from many institutions that if I get caught out, I will have an opportunity to fix. Now that is incorrect. If that is the perception from the industry, they can rest assured that there's a legitimate expectation from institutions that do comply with the law that action will be taken against non-compliant institutions.
What will that action be? Enforcement being a critical point here to seek that accountability and hold these industries to at least a set standard that it is a country duty that South Africa seeks to get off that grey list.
Absolutely, you are spot on. So since November 2023, we have been issuing notices of intention to sanction, which is very much tailored along the lines of an admission of guilt fine. We're not after the fine. We are after the compliance aspect. So what is required in these sanction notices is that you firstly ensure that you do submit your RCR, and then that you pay a financial penalty. The problem is that some of the institutions do pay the fines and they do submit their RCRs. Another batch of institutions submit their RCRs, but they neglect to pay the fine. And the problem that we face is that we will have to take further action against those institutions who ignores us, and the penalties will drastically increase. and we will take more stringent action the later and the longer the non-compliance persists. So institutions that are still not compliant will face the consequences. That is beyond question. The only question is, do they want to mitigate that risk and ensure that they do comply in the meantime and mitigate the risk, or do they really want to drag it out to a situation where we have no other recourse but to up the financial penalties?
Finally, at this rate, in your view, is South Africa set to meet the target that has been set, that deadline by the FATF? It's fast approaching.
It's fast approaching. Some good news that I can give is that in June at the plenary at FATF, the FATF gave us a thumbs up in respect of the RCR tool that we have, that South Africa and the FIC has devised, which enables us to assess the RCRs and determine which are the higher risk institutions. So the tool is working perfectly well, and the FATF accepts that, and it is just a concern for them that there is not a proper uptake of submitting that information which we so crucially need. I have to tell you that every effort is made from South Africa's side to get us off the grey list. But as a country, I think we need to accept that each one of us has a role to play. Whether you find yourself in a criminal sphere, an investigative sphere, or a regulator, or where you are an accountable institution, you need to meet those obligations and meet them properly. And that's why we request, and the RCRs is but one aspect of the compliance. If you look at compliance of the FIC Act, there are so many aspects to it, and it raises a serious question. If these institutions which have not submitted their RCRs, are they not high risk? Yeah. And are they not simply not submitting because they are high risk? We deem them at this stage as automatically high risk. So what they've done by not submitting their RCRs is they've actually red flagged themselves by their non-compliance.
Thank you so much for your input. Jan Augustyn is with the Financial Intelligence Center. They're talking to us about industries that have been identified as stalling the progress of South Africa's exit from the grey list.